I'm sure you've heard some of these myths when it comes to child custody cases. No child support, no visitation. You have to fight for full custody. Getting remarried helps you to win custody. Mothers always get custody. This week, we will take the time to dispel a few of these common myths that we've encountered in our law practice. We often get calls from individuals who have been denied visitation because they didn't pay their child support. We also get calls from people who want to withhold their child support because their ex won't let them see their children. In Texas, child support and visitation are two separate matters and are in no way dependent on each other. In fact, a court may not render an order that conditions the right of a conservator to possession of or access to a child on the payment of child support. That means that a court cannot legally enter an order that says you will only get visitation with your child if you pay child support. So, what happens when the other side denies visitation or refuses to pay child support? Any violation of a court order regarding child support or visitation may be enforced against the parent at fault. If a parent is withholding visitation or fails to make their child support payment, the other parent can seek criminal and civil contempt against that parent and request jail time, probation, and/or a $500 fine for each offense. It is important to note that if a court finds that a parent has failed to make child support payments as ordered or has prohibited visitation with the child, the court shall, which as we know means must, order the person in violation to pay the reasonable attorney's fees of the other parent, as well as court costs. A separate child support payment will be ordered in addition to the current child support payment to require that parent to make up any child support arrears that they now owe. A parent should not take matters into their own hands and withhold visitation or child support based on the behavior of the other parent. Always remember that the best interest of the child is at stake, and withholding support or visitation is rarely in the child's best interest. Quick plug. If you're enjoying this video, click the like button. Or you could just send me a nickel, but one of those is cheaper. There is always some confusion when custody of children is involved. There is no such thing as full custody. Under Texas law, we use the term conservatorship and possession and access. Conservatorship deals solely with the rights and duties of each parent in regard to the child. For example, these include the duty to pay child support, the right to make decisions concerning the child's education, and the right to make decisions concerning the child's health care, and so on and so forth. A parent may be appointed as a sole managing conservator, a joint managing conservator, or a possessory conservator. A sole managing conservator is awarded the right to make all major decisions concerning the child without consulting the other parent first. Joint managing conservators must make decisions together and consult with the other conservator to the extent possible before making any major decisions concerning the child. Both sole and joint managing conservators are entitled to possession of and access to the child as ordered by the court. Possession and access, on the other hand, concerns a parent's right to spend time with their child. Sometimes people refer to this as visitation. It is the public policy of Texas to ensure that all parents who have shown that they can act in the best interest of the child to have frequent and continuing contact with their child. There is a rebuttable presumption under Texas law that it is in the best interest of the child that the parents be appointed as managing conservators of the child. If it is determined by a court that a parent should not be appointed as a managing conservator, it is then presumed that they should be appointed as a possessory conservator. A possessory conservator gets possession rights, but doesn't get to make any of the major life decisions for the child. In most instances, a person who is seeking full custody is seeking the right to make decisions for the child and to spend the most time with their child. Therefore, they are seeking primary conservatorship as well as the right to designate the child's primary residence. There is a myth that single parents are not as stable as those that are married. Occasionally, we get a client in our office that is engaged and wonders if getting married quickly will make them look better in the eyes of the judge or the jury. The Texas Family Code, however, specifically states that a court may not consider marital status of the party in determining who to appoint as sole or joint managing conservator, or in considering any terms or conditions of conservatorship, possession of, and access to the child. This thought often leads to another myth that mothers always get the child in Texas. The Texas Family Code states that a court may not consider the sex of the party or the child in determining who to appoint as sole or joint managing conservator, or in considering any of the terms and conditions of conservatorship, possession of, or access to the child. While it is historically true that more mothers than fathers are given the right to designate the primary residence, it is untrue that it is impossible for a father to get primary custody or to be granted sole managing conservatorship. Also, times are changing, and we are seeing far more fathers awarded primary conservatorship these days than we ever have. As I stated a moment ago, the court must make any and all determinations concerning conservatorship and possession of and access to the child based only on what is in the child's best interest. Is there a child custody myth that we've missed? Leave it in the comment section below and we'll include it in a future video. From all of us here at Matthew Harris Law, we appreciate you watching.